CLE. This is a joint effort by the Washington Defense Trial Lawyers and the Corporate Counsel section of the Washington State Bar Association. My name is John Maroney, and I'll be the MC for today, and I'm joined with two fantastic speakers. With me today is Derek Bishop. Derek is a partner in the Employment Practice Law Group at Gordon Reese Scully Mansukhani, and he helps clients across the nation with complex employment matters. He regularly counsels employers on workplace issues, including disability accommodation, wage and hour issues, and other employment issues. When necessary, he defends employers against employment claims, including wage and hour violations brought by either individual employees or on behalf of a class of employees. Derek also chairs the Employment Law Committee for the Washington Defense Trial Lawyers. Also with us is Eric De Los Santos. Eric recently joined Facebook as an Associate General Counsel. Prior to this, he was Deputy General Counsel, VP of Legal, Employment, and Ethics for TrueBlue. He also chaired TrueBlue's Diversity and Inclusion Council. Eric is a frequent speaker on employment law and diversity and inclusion issues at the national and local levels. He is very active with the Association of Corporate Counsel, and last year served as its chair of the Employment and Labor Law Network, which has over 7,000 members. Several years ago, the ACC presented Eric with the Matthew J. Whitehead II Diversity Award, which is the highest award given to an in-house attorney for improving the employment, retention, advancement, and career path opportunities for lawyers of diverse constituencies. Eric is also a founding member of the National Filipino American Lawyers Association and is its immediate past president. You'll hear from me chime in from time to time, so I'll tell you a little bit about myself. I'm a trial lawyer turned in-house counsel. I was a partner at a large law firm in Seattle called Williams, Kastner & Gibbs. I tried case to verdict before going in-house. I currently work as a director on the legal team at Holland America Group, which services several cruise brands. Predominantly, I'm an employment lawyer advising human resources and managing outside counsel on all employment litigation claims, but I also manage other litigation matters as well. I'm also on the executive board of the Washington Defense Trial Lawyers. As I said at the outset, this is co-hosted by the WDTL and the Corporate Counsel section of the WSBA. We encourage corporate counsel members to supplement their great membership with a free membership in the WDTL, where you can have access to free CLEs like this. We also encourage our WDTL members to supplement their membership with a corporate counsel membership, where they can broaden their practice base and network with in-house attorneys from across the spectrum. A couple of notes before we begin. We will take questions during today's CLE. So if you have a question, please use the Q&A function and not the chat function. So I'll be monitoring those questions and finding a good space to ask the question. If we don't get to it during the presentation, one of us will get back to you in the next 24 to 48 hours. Derek has promised to do that himself. Second, the CLE has been approved for credit and is being recorded. The recording will be available after today's session. You can access the CLE later by visiting the WDTL website. And finally, the CLE is part of a two-part series. The first presentation took place 2 weeks ago on workspaces in the age of COVID, and it's available for download on the WDTL's website. So check it out if you missed it. With that, I will turn it over to Derek.
Thanks, John. And hearing Eric's bio, I had no idea that he was such a fancy guy. So we're very lucky that he's joining us today. Although we miss Elaine from part one, and hopefully you guys were there to see that one as well. So thank you all for joining us today. Today is part two, like John said, of our COVID return to work series, I guess. Today we're going to be talking mostly about employers and employees who are transitioning from a strictly office-based work environment to more of a remote work environment, and some of the legal issues that come up around that, and best practices from a legal perspective on how to address those. So this is just a little bit about our firm, Gordon & Reese. It's a big firm. Nobody cares about that. So first and foremost, and I think this is important that everybody knows in terms of any changes that you're making to your policies or your work environment, and that's, people think it goes without saying, and trust me, it doesn't, but good management is essential. And good management starts with having good policies. So one of the things I'm not going to say throughout this, although I'm hoping that you know it's implied, is that anything we talk about today, check your policies before making any changes and make sure that they match whatever changes you're going to make. And just real quick, some thoughts on those policies, since that is the number one thing that I talk to with clients. One is always to review and update your policies to make sure they match law. When there's multiple options available to you to meet the legal requirements of the law, you want to make sure that you set your policy to best match your needs and culture. And if possible, you should keep your employees and their well-being first, if possible. Employees will forgive a lot from an employer if they think the company is treating them fairly and keeping their needs in mind. So, for example, if you set up a remote work policy and it ends up that somebody's left out on the call, they will think it's a mistake and won't consider further legal action if they think that you have the employees and their best interest in mind. And then the last thing I want to say just about policies is once they're set, you need to trust them and follow them. My first question whenever I talk to a client and they say, hey, can we do this? I say, what does your policy say? If you're not following your policies, you'll hear about it from both employees and their lawyers later on. So if you take one thing away from any employment-based CLE, it's to set your policies, make sure that your policies comply with the law, and then make sure that they're consistent with your actual practices. Eric, I know when we had talked, you had some thoughts on how to return employees to work with these thoughts in mind.
Sure thing. And just along the lines of having good policies, make sure that because the laws are changing quickly at all different levels of government, to make sure that your policies are not only in alignment with federal and state law, but also local laws and any other type of industry specific kinds of guidance that's being issued, because it's real important that they be in compliance with all of those areas. Yeah, I mean, it is critical that good management is important during these times, just because the law is ever changing, and this is a new thing that's happening. And having trust in your employer goes a long way in terms of making sure that any misunderstandings or missteps are going to be looked upon by the employee as being, part of an honest mistake, and not necessarily one where folks are going to see as the employer as being bad in all of this, because again, this is all new stuff. I did do some homework last night, and I found out that as of the end of August, Derek, we have had 588 lawsuits filed related to COVID across the nation, with California, of course, leading, and a lot of lawsuits also in Florida, New York, and New Jersey. And the number one complaint type that is being filed is actually for retaliation. And it's interesting because a lot of these claims are from essential workers who are claiming that they are not getting the PPE that they need, and or issues related to the safety of COVID, while at the same time employers are faced with making tough decisions related to employment. For example, putting people on furlough, or whether they need to decrease people's scheduling. So all of that is kind of coming to a head. And the result is, of course, all these claims for retaliation. But I just thought I'd share that to give us a backdrop of what we're looking at.
And Eric, if I can piggyback on that retaliation, give you the trial perspective. So retaliation, from a defense trial lawyer's perspective, is one of the most difficult claims to defeat, because it's a process crime. And you can always do more to protect against an employee who has complained about something righteously and not taken adverse employment action that they could argue was somehow related to that gripe. And so, the way it would come up is someone saying, you're not providing me with enough PPE. You say, we're doing the best we can, and you genuinely mean it. And then that person all of a sudden starts losing some shifts. they have some kind of adverse action in their employment where a reasonable person would think that it's wrong and it's somehow related to the fact that they spoke up. So as you're dealing with employees who do lodge those gripes related to whether or not you're protecting them, just make sure that you are papering everything you do with, as Derek said at the outset, treating your employees well, putting them first, and doing whatever you can to make sure that the action that you might have to take as a result to slow down in business, slow down in work, cutting hours for some staff and not others, make sure that it is objectively independent of anything else that might be argued as far as a retaliatory animus. So that's the trial lawyer perspective. Thank you, Eric.
That's exactly right, John. And it also shows the importance of having these policies and having the remote work process is thought out, so that you don't end up with a situation where an employee is able to claim that they were retaliated against because I had to come back into the office, whereas Joe down the hall wasn't able to.
Right.
So when you're kind of developing a remote work policy, the first question to ask yourself really is, where is the workplace going to be? There's multiple options. Working from home, which I'm defining as working from a specifically identified workplace outside of your office. So my workplace is my beautiful basement, for example. Whereas working remotely, you would allow your employee to work from wherever they wanted. If they wanted to work at the Starbucks up the street, great. If they wanted to work in and from a hotel room in Cabo, awesome. It doesn't matter where they're working so long as they're getting the job done. Another option that's upcoming is hoteling or a co-working space. Hoteling is where you have offices available in your workspace and have workers come in, and I need an office for Tuesday. I'll come into the office on Tuesday. I'll work in my office there and work from home or remotely the rest of the time. Co-working spaces, WeWork, Riveter are two that I know of, and that's where you rent a space that your employee can go to. Another option would be part-time in the office, right? So Mondays and Wednesdays, you come and work in the office. Tuesday, Thursday, Friday, you work from home. Any of those are fine, but you do want to make sure that you have that defined and you have those in mind as you're developing your policy for a number of reasons. For example, if you do allow employees to work remotely and you have an employee that says, "Oh my gosh, thank you so much. I really appreciate that. I've always wanted to live in Wyoming," and they move to Wyoming, they work from Wyoming. Well, at that point, you have unemployment, workers' comp that you may need to pay. You may have taxes. So before you let somebody just work remotely from anywhere, you might want to think through some of those issues.
So what I think Derek is mentioning is if someone ups and moves to Wyoming for 3 months while they're during the work from home processes, you may have state and local taxes in the venue where the person goes to work. And that hasn't been, so you might have them set up as an employee in Washington State, having deductions for work performed in Washington State. But if you go to California for 3 months, for example, you might have to worry about not deducting income tax for the state of California. So just make sure that you keep an eye on your workforce. And some workforces just aren't really paying much attention. It's kind of, I don't want to know, so you don't ask questions. But if you're an employer and you have knowledge that your employee is working in a foreign jurisdiction and you're not deducting, those required deductions, that could become a headache for you down the road.
Absolutely.
And someone just pointed out, one of the panelists pointed out business licenses too. Great point from the panel. The audience is that if you may not even be set up to do business in a state where someone is working. So, it's just important to keep tabs on your personnel and your employee base.
So Eric, who can work remotely and who has to work through return to the office is a big decision. I mean, have you advised your client about that, or how how would you go about that?
So in a lot of ways, right, it'll be first and foremost a practical consideration, right? Some people physically have to be present in the place of business just because that is what the job is all about. And then, of course, you have the situation where you have a lot of people who are office workers or who don't necessarily aren't customer facing. And that's where it becomes a little bit of a conversation that needs to happen in terms of how do you decide who gets to stay and where. Now, underlying all of this, of course, is the rules from the government with respect to where people can, governing the workplace. But aside from all that, I think it's important to make sure you have stakeholders who can advise as to whether or not certain positions need to be at the office and which ones don't need to be. I know of organizations that have remote from home managers who are responsible for bringing all these stakeholders together to have conversations and to identify the positions and then to continue to monitor to see if certain positions can work remotely as opposed to others. But I think it's all about having a process that's transparent and can be and is as fair as possible, taking into consideration the industry and the needs of the business.
I think that's exactly right. And I just a couple of points that I'd like to add to that is to remember when you're making the decisions as to who can and who can't work from home or work remotely, you want to make sure you make that decision at the job description level as opposed to the individual level. If John Maroney as a person can't work remotely, but the position that he does could work remotely, that's a John issue. It's not a position issue, right? So make sure you keep that at the job level, and that will also help with any retaliation claims, right? If I say John can't work remotely, and John had concerns about PPE, all of a sudden John's got a retaliation claim against us. Whereas if I say the accounting staff that John is part of can't work remotely, it's much harder for him to then say, oh no, this was directed directly at me. A couple other things to keep in mind. You want the decision to be made at the highest level, so that it can be more uniform. Now, for large corporations like True Blue or Holland America or Facebook, you're not going to have Mark Zuckerberg figuring out, okay, the AP staff has to work in the office, but you also don't want the accounting lead to make that decision. So you want to make sure it's at a high enough level that the decisions can be made uniformly across the organization as much as possible. The other thing to remember is that you want to make sure that you include all the necessary stakeholders. A lot of times people will forget the other departments that the job position will report to or interface with. Make sure that you have their buy-off. You want to make sure you have IT, compliance, risk management there, so that they can point out to you, hey, these are going to be the IT requirements that are necessary. These are going to be the risks that you're posing. Make sure if you let somebody work in California that we're getting taxes from them. And then last, any decisions that are made in terms of these positions can work from home, these positions can't. A thoughtful proposal with the justifications why that needs to be done is helpful. Even if it's just an email, that way when, as Eric said, or John said, if there's a retaliation claim, we can, as a litigator, can hold that up as Exhibit 1 and say, look, here's the reason he wasn't brought back. It has nothing to do with him. It has to do with this business reason, this business reason, and this business reason. And we'll go a long way to helping knock that out.
And as we go into this slide, Derek, we have two questions from the audience. I think one of them will probably fit its way nicely into this slide with about, it relates to privacy and confidentiality. So I'll read the question and then you two can tackle it as you manage the workforce, which is, are there privacy confidentiality concerns with allowing employees to work at a coffee shop or Cabo? They would likely be working on unsecured public Wi-Fi, which is susceptible to attacks. So that's part of managing your work from home workforce. The other one is, are you recommending that you ask employees to disclose where they are working, or can you just remain blissfully ignorant and assume they are still local? I think as an employment litigator, blissful ignorance is never an excuse. Washington is a very progressive state and employee rights are paramount. For example, it is a criminal act to wrongfully withhold wages from employees. It's not just a civil penalty, but you can also face criminal penalties as an employer for wrongfully withholding those wages. So I think, you know, to the extent you can as a best practice, get that pinned down. That being said, I would venture to guess that very few employers are doing that because it is a very difficult thing to manage. And, you know, everyone's having it, in reality, everyone's having a tough time right now, right? I mean, we've been stuck at home for months. And if your workforce wants to go hang out in, you know, Wyoming for a while and hike, like, do you really want to be the wet blanket that says you can't do it because we're not set up to work there? So, you know, aside from the litigation things that the lawyers always tell you to avoid, you have real world stuff that you have to deal with as an employer too. So I can't give you an answer to that question, but if it were to be a piece of litigation, ignorance would not be a defense. You as an employer will always be obligated to know where your employees are and to make sure that the deductions are being taken. So back over to you guys.
Yeah, thanks, John. And I think that's exactly right. The one thing I would add is the longer somebody is working from a space, the more interested the employer should be as to where that is. So if you have an employee that, you know, I went to a wedding back in Michigan, did some work over the weekend. My employer didn't care. And I wouldn't expect them to know that I was working remotely from Michigan over the weekend. If I was going to be there for 3 months, you would probably want to make sure that you get an updated address for me where I was working. So as far as the privacy confidentiality concerns, yeah, I mean, I think there, to the extent your company has those, absolutely. I don't necessarily know that an employer has an obligation to its employees to provide them with a private confidential space to work. If your clients or your business needs require that information remain private and confidential, for, you know, for lawyers, for example, we need to make sure that we have a private confidential space. And that's something that you should include in a policy to, when you're providing, you know, this is what an acceptable workspace is like. If there are privacy or confidentiality concerns that you have, or is a need for a secure Wi-Fi connection, all of that should be disclosed.
Eric, I'm interested in your thoughts. You work for, you know, Facebook, an online tech giant. You know, what are your thoughts there?
So, you know, everyone has a responsibility when it comes to privacy and maintaining company secrets, and particularly when working using your computer, for example, right? And so the tech people will make sure that we have the things in place, or the systems in place, to ensure security in that respect. But it really is incumbent on the employee to use their good judgment in making sure that they're doing all that they can to protect company information. I would expect that companies nowadays would have folks who do work remotely or you know, telework, and so would already have policies regarding how to, and best practices for how to guard information. And if not, there's so much out there on the, you know, so much examples of these types of policies out there that if you don't have one, you should become familiar with it, in addition to training of individual employees and putting them in certain hypotheticals to talk about what they should be doing if they were in a coffee shop, and if they were doing some work on a laptop, for example, making sure that that's ingrained in all your employees so they understand the importance of doing that and how to go about using good judgment in those situations.
So as far as the managing of a remote employee, having been a manager of remote employees in the past, productivity is usually the biggest hurdle I hear from clients and that I always had. It's a much different world with remote employees than it is with somebody who you can walk past their desk and see them at their desk and okay, they appear to be working hard. So you really can't use that gut type management, that face time or that working hard metric in determining if your employees are being as productive as they can. The best thing you can do is to make sure that to the extent possible, you have some sort of objective measures. You need to make this many widgets per day. You need to make this many sales calls per week. You need to process this many invoices per hour. However that is, make sure you share those objective measures and then follow up on those objective measures. If somebody can, and the other thing is to manage against them. If somebody can hit their objective measures in 4 hours, maybe they measures are too low. Or maybe they're great and you should just pay them for 8 hours and they get all the work done in 4. And hey, they're ahead.
I have to smile at this one, Derek, because I know we were talking about this one yesterday, because I think when this was all going down, I was still at True Blue. And I remember when the whole conversation about having people work remotely came about, one of the first things that came up from folks is, well, how do we make sure that they're even going to be working and being productive while at home? And several months later, now we're hearing from folks that, wow, I've never worked so hard in my life. And productivity, I mean, the company's really getting the most out of me now that I don't, they have more hours, I have more hours available. And I'm talking primarily of course, for exempt employees. And so it's interesting now, right? What is productivity in this day and age? How do you measure it? And I think this is a really good opportunity now to be surveying your employees and getting their read on their perceptions at the very least as to how things are going. Do they feel they're more productive or less? Are there things that are hindering their ability to work remotely? I think it's a good time to start gathering that data. And once this is all over, I think that'll be very helpful in assessing where the company goes from there with respect to this remote work issue. But yeah, this productivity one is quite could be a hot button. Was a hot button originally for folks, but I for one can tell you, I think I'm seeing a lot of people work more than ever before.
Well, I think that's exactly right, and I think it's created a little bit of a divide between what I used to know as working from home and actually working from home. So, and I think that's right. I mean, I think managed well, productivity there'd be no reason to have a diminution of productivity. Communications, I think, is another area that people don't really think about in advance, because so much communication in the office is walking past somebody in the hallway and, oh yeah, hey John, did you get that thing? Or seeing somebody in the lunchroom and talking about, oh, this upcoming project, and that's not available to a remote worker at all. And the other issue that can arise is if you have some remote workers and some in-office workers, and making sure that those remote workers have the same level of communication as the in-office workers, so they don't claim that they're getting frozen out or somehow treated differently because, oh, I don't get as many opportunities because they're not communicating with me. As much as I hate to say this, to me, I think the best way to do that is just to have regular meetings, even if it's 2 to 3 times a week for 5 or 10 minutes, just to check in. Hey, how's it going? It doesn't need to be a long agenda. FaceTime, Zoom, video conferences, I think works really well for that. You can see the person, you can tell a lot about them, about how they're feeling and about how they're doing by, by their look alone. Are they well rested? Are they frazzled, etc. Another tool is action plans, where you kind of set up, here's what needs to be done to achieve our goal. And otherwise just to try to be as creative as possible in making sure that those management, that communication works. Or as somebody said, you can use chat functions, like the one that they have in Zoom or in Skype. Okay, so time records, I think, is another big issue. How do you maintain proper time records when you can't see somebody in the office? Now, specifically, what I'm talking about here really is time records that the employer keeps for reporting to government agencies, for things like sick leave, workers' compensation, employment security, sometimes health insurance. You need to report how many hours people are working. Of course, for lawyers, billing time, and for others, billing time and material jobs. Those, you all need to know how much people are working. For my purpose, the best way to do that is with a computer time clock, where people punch in the morning. If punch in the morning, they can punch in and out for breaks. They can punch in and out for lunches if you want, and that will keep track of the time that they're working. If you're going to do that, I do highly recommend that when you roll it out, you explain the purpose. It's not, for Big Brother to keep an eye on you or to try to chisel them out of time, but because we need to report these hours that people are working. Second best really is kind of a hard copy, the old-fashioned hard copy report of the time that's worked. The problem with that is how do you get that from the employee? Can't put that in their outbox for to be picked up on Friday or drop it off with the office manager. Somehow you need to get that to the office and then have that incorporated into your systems, but that also works. One other thought I have on this is to have both exempt and non-exempt employees
I'm presenting. Very important.
To have exempt and non-exempt employees report their hours worked, just so it can be, just so the non-exempt employees don't feel like they're being put upon.
And just on the keeping of time records, so this was an issue pre-COVID, making sure that non-exempt workers, when they're at home, if they're emailing from home off hours, there is no real off hours when you're doing work. And so it's become even more important for employers now, when people could really roll out of bed at whatever hour of the day and start their day, as long as they get their work done. If you're a results-oriented employer, and results matter more than when you do the work, you really have to monitor those hours, because you can slip into overtime issues if people are working beyond a certain number of hours a week. And so it's very important to, as much as possible in keeping up morale, try to stick to shifts, get those approved schedules in advance. Maybe someone does work a wacky schedule. I have a 6-month-old, so I start my day at 2 a.m. And so it's atypical, but that's my day. So, try to tailor what you can to your employees, but it is absolutely vital to make sure that you are paying them for the work that they're doing when they're working. And that includes text messaging related to work, emailing related to work. Anything outside the normal shift is compensable time.
And then also to this slide, I just wanted to add, I know we have here sick leave. It's really important that you make sure you abide by state and local laws regarding particularly COVID-19 leave laws. There are a host of laws that have passed regarding the requirement that we need to make sure we have accurate balances on these types of leaves for our employees, and make sure that we're giving them in the right increments that the law requires that we give them as well. So make sure you also check your local and state laws.
Perfect. And, so this really kind of gets more to what John was talking about with actual pay issues. Making sure that we accurately record the time for the employees. This is especially along the West Coast, wage and hour issues are getting more and more significant and more costly for employers as part of the cost of doing work. So in here, the big question I always get, and Eric, I'm gonna ask you this question. I have an employee, he works remotely. He says that, he worked 8 hours yesterday from 8 till 4 p.m. But then I saw on Facebook that he was going to see a movie in the middle of the day. Do I need to pay him for the time that he reported he was working?
If he makes an initial claim or he initially reports that he's working a certain amount of hours, I would absolutely take him on his word on it and pay him, and treat the issue of him not working or the allegation that he's not working separate as a performance issue. Conduct an investigation to find out if that in fact is true, but I would not try and withhold any type of wages pending the investigation. As folks in who have employees in California know, I mean, if you are found to ultimately be liable for these wages, there's a penalty, which can be much more sizable than what the initial claim was for. But absolutely take the employee at his or her word, and then take whatever necessary action should you find out that they were not being truthful in subsequently, and that they were actually not working.
That is much cheaper. That's fantastic, Eric, because it is much cheaper to pay someone for those 2 hours of work than to not pay them and get challenged that you wrongfully withheld the wages. Even if it is 2 hours worth of work, you can treble that. You can have what's called trebling damages in Washington as well, where you can get 2 times the amount. Legal fees on top of it are payable to the plaintiff's lawyer. So you have a lot of these lawyers who take these small dollar cases, and they get paid, that what ends up driving the biggest cost of the cases, several $100,000 in the other side's legal fees over 2 hours of work. So Eric is spot on. Just pay them the money and deal with it as a disciplinary issue. If you do an investigation, find out that they misreported, and then just terminate the employee if they're at progressive discipline levels where they could be terminated. And that's a much cheaper off-ramp to the problem than just spiting them and withholding 2 hours of work worth of pay.
Excellent answers, guys. Thank you both so much. You must be employment lawyers. And I mean, Eric, I know there's also some requirements to reimburse employees for business expenses. Yeah. So how have you dealt with that?
So, we are seeing a lot more people telework, and it's bringing to light the issue that there are laws in several jurisdictions that govern having to reimburse employees for expenses related to telework. You have some places where you'll have to, for example, provide a percentage of costs associated with internet use or cell phone usage. So be sure that wherever your employees are located, that you are aware of the laws that govern these types of reimbursements, and make sure you adhere to whatever you need to do in that depending on what you learn.
Yeah, is California one of those jurisdictions?
Yes.
And so I think California is the biggest one, and as far as I know, and you guys probably have a better judgment on this, but I think they in Washington are kind of trying to outmuscle each other for most employee friendly and then plaintiff's attorney friendly laws as far as employment goes.
Yeah, and Chicago as well. I want to drop that. I know always having a talk with an attorney, and one of the concerns is that once this COVID thing is done with, that this this might be a potential area for plaintiffs' lawyers to kind of pursue, is the reimbursement of expenditures that, to employees, business expenses. So,
you know, the other issue that comes up here, and I think John mentioned it, and I think it's more of a management issue than anything else, is an employee, for example, that has, you know, rolls out of bed, checks their email, you know, sends a few emails or whatever before their day starts. They don't necessarily think of it as time that they're working, right? They're just checking their email. But an employer, I should say, they don't think about it as time working until later they decide to engage in some litigation with you. So at which time it was 100%, it was 100% time worked, and you owe me overtime up the wazoo. So one thing to make sure it's in your policy and to keep an eye on is making sure anytime you get a sense that somebody is working, you know, be it before their reporting time or after their reporting time, make sure that you let them know that, hey, that is work time. Don't do it outside of work hours, or if you do it, make sure you mark it down, you bill us for it, because we intend to pay you for that. This here is a place where blissful ignorance is definitely going to come back and bite you right in the hiney.
And to follow up on something both Derek and Eric said earlier on, so you know, someone is not necessarily going to run to a lawyer when they had to send, you know, 2 emails when they rolled out of bed on their iPhone. They usually, you know, just set those aside. When those become problems is when someone is being treated unfairly, and then they start remembering all of the things that they did over the last 3 years, because there's a statute of limitations for these types of things, and you treat an employee unfairly, they remember, and then they have the document trail that's already created because there's an auto receipt on the email that was sent, there's the records that were kept for when they clocked into work, and then you are creating as an employer all of the evidence a plaintiff's lawyer needs to file a class action lawsuit. And then all of a sudden one small problem becomes massive, and you start having to work with, you know, a large scale payroll issue because you didn't pay people for, you know, the time that they worked. So is that likely to happen? I can't tell you it won't happen on a continuum. I mean, you probably, you know, we all do it, so I don't know how likely it is, but you know, some people in life are just unlucky, right? We all know the person who stubs their toe all the time or gets an offender bender when they're on hard times. Some people are just unlucky, and it's when you're unlucky that one of these problems, you know, the head comes up and you have to deal with it. And so the best thing to do is just actively manage now, so it's not an issue later.
Exactly right. And if, when it does become an issue later, call me. I'll help you out. Okay, rest breaks and meal periods. This is an issue that, especially up and down the West Coast, is becoming a bigger and bigger and bigger issue for companies, where I don't know if the law, but the practice for the first 30 years of my working life was basically, hey, especially in an office or other environment, if you need to go to the bathroom, you know, or do whatever, have at. It's not necessarily the old-fashioned, you know, Flintstones version of, you know, the whistle blows, everybody says, all right, it's time to smoke them if you got them. Let's have our break. But courts up and down the coast really are demanding more and more kind of formal breaks, making sure that employers take those actions necessary to meaningfully promote rest breaks and meal periods. And if what happens is you get an employee, that disgruntled employee comes back and says, oh yeah, and they never even told me I could take a break. And they then get into a class action, and you know, you're turn around and you're in the middle of a class action lawsuit with all of your employees. So it is definitely something to keep in mind. For remote work, I think it's even more difficult than it is for in-office work or in-person work. You can't see somebody at their desk or not at their desk or at their workstation, so you can't tell if they've taken a break or they haven't. John or Eric, have you either of you had to deal with rest break or meal period issues?
I mean, yeah, I mean, just to reiterate, I mean, I know that there are at least 20, there are 20 states now that have some form of law that kind of dictates what needs to happen with respect to meal and rest breaks. And Oregon and Washington State, in fact, there's an affirmative duty to ensure that folks are actually taking their meal and rest break periods. And there's always been like talk about, well, how do we kind of mitigate this risk and make sure that folks are doing it? And there have been practices that folks have employed. One is which is to just kind of have folks, employees understand the policy as it relates to meal and rest breaks, and to sign off on that policy, and then to continually remind folks about that, particularly during this time of working remote. I think it goes. It'll go a long way in the event that there is a claim that is filed to show that you were consistently informing your employees.
Yeah, and I would just say the same in Washington, California, for example. We have businesses in both, so it's pretty structured. The laws out there structure how a workday is supposed to look, and so you should follow the structure. And just as a general guiding principle, the one thing I would say is, your employees are probably not going to care that much if this goes back to just treating your employees well. I mean, if you are treating your employees well, then that gets you a lot of working capital with your employee base. But where you want to, the areas where you can certainly get into trouble is when you are playing games with your employees on when they get their breaks. I being a partner at a firm with I had my own set of clients before I became beholden to one, and I had clients who, it seemed like it was just everything was almost like a game to get their employees paid or their breaks. I think Derek probably has seen those types of clients too. Those types of clients make you want to rip your hair out, because you're in Washington and California, you are the employer. It is your job to pay your employees. It is your job to make sure that your employees get the breaks that they need and that they've earned. And that's the way the law and the courts look at it. It's not an excuse to say, well, so-and-so did this and this. It doesn't matter. And so as long as you are guided by the principle of just doing what's right, which not all employers do, but if that can be your guiding principles, what's right? If they've earned the break, let them take the break. And you'll avoid a lot of headaches later by claims from employees who feel like you're just playing games with them and their break time and their meal time and their payments.
And so, absolutely, John. And really, the two biggest things I hear from clients is either they believe an employee is shirking. That's to say, they're taking, instead of a 10-minute break, they're taking a 15 or 20-minute break, or instead of a half-hour lunch, they're taking a 45-minute lunch, which, to me, unless it is a position where you have somebody who's coming to relieve them, I don't care if they're getting the job done and if they take a 20-minute break instead of taking a 10-minute break and surfing Facebook while they're back on the clock. That's fine. It's to me, it should be a productivity issue. If it's a situation where there's it's a customer facing position and somebody needs to be relieved to take a 10-minute break, then it can become a larger issue, but you still want to give a couple of extra minutes of care there, as opposed to trying to really crack down and say it's 10 minutes and 1 second is too long. The other thing go ahead.
I was going to say, before we move on to the next slide, I didn't know if that's where you're headed, Derek. I wanted to ask Eric. So Eric, working for a tech company, tech companies have this I guess maybe stereotype that it's a lot more relaxed. Maybe you have beanbags around everywhere. People work from wherever they want. But that's definitely the trend in Seattle of office spaces just being more of this relaxed work zone and focusing maybe more on productivity, giving much more lenient leave, unlimited. You've heard about that from employers, unlimited vacation. So how do you maybe see that trend? You've had two very different employers, from TrueBlue to Facebook. What kind of trends do you see with respect to meal and rest breaks and leave allocation as well, which will probably have its impact on working from home? I'm just curious.
I think it really depends on the industry. I think that there's stark differences depending on what kind of business you're in, and of course, also with respect to the population that you are employing. I think if you have populations considered more vulnerable per the EOC perception or standards, I mean, workers who make a lot less than in the tech industry, I think there's going to be a lot more focus on making sure you are adhering to and complying with the laws with respect to meal and rest break periods. But I'm still trying to reconcile. These differences and approaches to these different populations with respect to productivity and what is acceptable and what is the company willing to provide. Definitely, if you're in the tech industry, I think you have more latitude in terms of being able to provide more to your employees and also expect that demand more in terms of working beyond. We have a lot of exempt employees, for example, that work a lot of long hours. But I come back to me in about 6 months. I'll have a better sense on that one.
Deal.
Yeah. What's interesting? Go ahead, Derek.
No, I was just going to say the other thing I hear is, and this is probably more common for Facebook, for example, is employees skipping rest breaks or skipping their meal periods because they don't. I didn't need a break. Whatever, or I'm going to skip my lunch and clock out a half hour early, and I just want to make sure everyone is aware, and especially it's still true for remote workers. You don't get, an employee cannot skip a rest break ever. It is absolutely unwaivable. So to the extent any employee ever says, "Oh, I don't want to take a rest break," unfortunately, you can tell them that the state does not allow them that discretion. Meal periods are different in that they can be waived. But if an employee is going to do that, you do want to have it in writing so that you can use that to establish that they did it voluntarily and freely of their own volition. Even then, I have some concerns that they're going to later claim that it was done under duress or whatnot. But to allow them to do it without something in writing, I would be very reluctant to ever allow that to happen. So the last thing is, I think, a place where people can get into a lot of trouble in a hidden way, and that's really the requirements for the remote workspace. There really is two separate considerations. At least one is providing a safe workspace, and that's in compliance with OSHA and WISHA, and providing a productive workspace as far as technology and everything else. Eric, I know you've had a lot of thoughts about the OSHA ergonomic requirements.
Yeah, I'm interested to see what transpires as the longer this remote from home continues, right? Because I think at some point folks are going to get tired of their workspace or working from home workspace, and if it goes longer than expected, I think we'll probably hear more complaints from our employees regarding the work from home environment, and the expectation that the employer do more. Now, I do think along the lines of providing a safe work environment, employers would be, should all be providing guidance to their employees about what they need to do in their particular homes to ensure basic safety, right? And so make sure you have that guidance in place. But I'm curious to see what will happen. I do think that at some point folks will tire, and then we'll see some creative requests being made, all under the guise of either providing more safety in the space or accommodation even of their workspace at home.
Yeah, no, I think that's exactly right. I mean, and I think that presents a great issue. I mean, so often we hear as an accommodation, employees request, oh, I want to work from home. Eventually, if you have a remote worker, the accommodation isn't going to be, I want to work from home. The accommodation is going to be, I need a stand-up desk in my home. I need other technology to help assist, just like they would in the office. And I would think that I think an employer would have the same obligation to provide that to them at home, if that's where their workspace is, as they would at the office.
Yeah, we're one of the interesting things, one of the interesting things about the COVID life right now is that we are in large part applying pre-COVID laws to this COVID universe in which we live. And so Eric's right, who knows what 6 months will bring. Before COVID, Derek has probably seen this. I had cases where someone couldn't work from the office, so we had to provide a reasonable accommodation to work from home because the job duties allowed it. I don't think so. First point, I don't think you will ever be able to say that working from home is not a reasonable accommodation anymore. If your business has stayed afloat with your entire workforce working from home, odds are after the vaccine comes out, you're going to be having to provide accommodations to work from home. Is my gut feeling. And then secondly, pre-COVID, working from home, if you needed to work from home, and then you also needed a reasonable accommodation. I had a case where someone had a health issue. And so without getting into the details, there was a requirement. It ended up going to trial, and it ended up being a requirement that, the employer the employer provided so many things for this worker, from an ergonomic chair to a desk to, sit stand. I think at the end of the day, it was like almost $75,000 worth of accommodation stuff. But at the end of the day, it still wasn't enough. And the employer could have done more. This was when I was at the Attorney General's office, so it's all public record. The employer could have done more in order to provide, an accommodation for this individual to work from home. So what I'm saying is, pre-COVID, reasonable accommodation laws are very employee friendly, as you would imagine. That's a theme throughout this presentation. But that was when, maybe a select few workers were working from home. Now we have everyone working from home. And what do those pre-COVID laws mean in this universe? I think it'll be very interesting to find out over time just how much is required of an employer who's trying to keep a business afloat when you may not have much revenue, and trying to keep your employees employed. Are you then also required to spend tens of thousands of more dollars to provide accommodations? Are those reasonable in today's day and age? That's going to be an interesting question going forward. We had one question from the audience. It's 3:59. We have a hard stop at 4:05. A question from the audience was, can you speak more to the meal rest compliance risk for exempt employees versus non-exempt employees? Does an exempt employee schedule flexibility mitigate that risk? So Derek, Eric, I don't know. I think, Derek, this might be right up your wheelhouse for your employer advice. So what do you think?
Yeah, no, I think that's absolutely right. For an exempt employee, I think the meal and rest periods are less important to keep as strict a track of. I still, for my money, were I a business owner, I would just roll it out across the entire company, just to make sure that it's well embedded into the culture of the company that rest breaks are um, not only required by law, but we support those, and we promote rest breaks and meal periods here. For the other thing for my money is it makes me a more productive worker if I can get away from my computer for a half hour and go eat a sandwich. I can come back. I'm more energized than if I just am plowing through. But that's how I would deal with exempt employees as well.
And I just want to say two things. One point is, yeah, this is all a new area, right? And I think the ultimate issue is really getting a good work-life balance going on. So in addition to complying with the law, I think to the extent that companies can rethink what it means to have work-life balance while working at home, I think it's important to kind of think about and figure out what that means and make sure your employees are aware of that. Second of all, with exempt employees, there is one wage and hour risk, which I think if folks are grappling with, it's when an exempt employee starts to take on a lot of non-exempt duties in response to COVID and the pandemic, and whether or not that changes or has implications for their exempt status and whether or not they're entitled to overtime or for those kinds of functions. And just want to assure everybody that the DOL issued guidance right on that, saying that no, during emergency situations, of which the pandemic is one of those areas, one of those situations that temporarily having to take on an exempt employee having to take on non-exempt duties temporarily would not impact their status.
Well, and I do want to just, I know we're tight on time, but I just want to point out the hidden discrimination that could arise here. For example, if you are putting a requirement on the job that somebody has a private, quiet place to work, that may be fine for you and I. It may, but for somebody with children, for example, that may be less. They may be less able to do that. Do they then turn around and say that's some sort of a discrimination based on the fact that they have children? I would hope not, but I would also I absolutely expect to defend that lawsuit at some point. So when you're going through and trying to figure out the requirements for a remote work site for your employees, make sure that you can justify every single one of those requirements, even the easy ones. If you say somebody is required to have high-speed internet, well, does that impact rural workers or workers who live in low-income areas disproportionately? If so, is that a discrimination issue? Maybe. But it will be fine if I can then take the proposal that you had put together and say, no, we need high-speed internet because they need to routinely be able to make phone calls, which take this much bandwidth, et cetera. And that's why it needs to be high-speed internet.
Yeah.
And then I think we had one quick question about if an employer has, regarding providing equipment to employees and outside of the reasonable accommodation context. If the employer's office is available, so employees can come in at their options. Do these employers need to do things like buy employees furniture at home that duplicates their setup at the office? Is it a best practice to put a money dollar cap on that? For my money, if the employer provides a workspace in the office and says you can come and work in the office, that meets the employer's obligations. John or Eric may have different thoughts on that, but I don't believe that you have an obligation to provide 2 safe offices and two productive offices. So to make a long story short, no, you don't need to buy things that would duplicate the office setup if they have access to come into the office, and you're giving them the option to work from home if they choose it. John or Eric, I mean, do you agree?
I mean, it's just, that's a very tough question to answer, because I think you'll have to do an individualized assessment for each worker and each individual, and what do they need in order to do their job. B, whether someone can go into the office or not almost changes weekly depending on a governor's order or city, mayor's order. So you have to look at each particular person. You have to look at the status of work from home rules and requirements from the various layers of state and federal and local governments, and then finally there is an end to the continuum on what you're required to provide to your employees. And I think one of the areas might be, you may say you don't need you're working from your kitchen table is fine, we don't need to provide you with the desk. And I think that just needs to be your individualized analysis for that particular employee. But it is probably one of the most nettlesome questions that I think employers will have. And unfortunately, we can't allow, I can't provide a universal answer on what to do. So it's a tough one. Who knows, I think, is the answer to that question. If you use your gut and you try to do it right, is there a legal requirement that you have to buy a desk for an employee, for all employees who are now working from home, just as a blanket rule? No. But do you need to help people if they need reasonable accommodations? Is there a workers' comp related issue where they can't, sit for too long, so they need sit stand? Are you then obligated to provide that? There's so many layers of analysis that need to be done for that worker that you just need to walk through carefully. So we are up at 4:07. I just wanted to thank everybody for coming today. The CLE will be available for download after today. And, if you have any questions, feel free to reach out to the presenters at any time. And thank you so much. Stay safe and mask up.